Good afternoon, everyone. So I'm Angela Onwachiwillig, Dean of Boston University School of Law, and I want to welcome you to our annual Max M. Shapiro Lecture. So Max Shapiro graduated from BU Law in 1933, and he embarked on a successful 60-year career as a trial attorney. In addition to his remarkable dedication to each and every case that he tried, Max embraced the role of mentor. He inspired young attorneys throughout his career, and he did it through the strength of his character. Shapiro Lecture serves as a fitting tribute to the memory of a lawyer devoted to advancing the cause of legal ethics and trial advocacy. And we're grateful to Max's son, Andrew, his daughter, Sue Ellen, and her husband, Larry, for funding this endowed lecture to honor his legacy. So today's speaker is Harold Goodman, a graduate from our class of 1969, who also received a degree from BU's College of Arts and Sciences in 1966. So less than 1 year after graduating from BU Law, Mr. Goodman argued his first case before the Pennsylvania Supreme Court, a First Amendment case on behalf of a low-income consumer advocacy group. A unanimous decision in his client's favor sparked a career-defining commitment to fight for victims of injustice. And throughout his career, Mr. Goodman has been a formidable advocate in both trial and appellate courts. On 4 occasions, he has briefed and argued cases before the United States Supreme Court. In addition, he's argued and won more than 10 cases in the Pennsylvania Supreme Court and more than 30 cases in the United States Court of Appeals for the Third Circuit. Mr. Goodman has argued many landmark cases related to racial discrimination and workers' rights, and he's represented numerous clients whose civil rights have been violated. We are extremely proud to count Harold Goodman among our alumni, and we're delighted to have this opportunity to hear from him today. I want to thank you all for joining us for the 2022 Max M. Shapiro Lecture. It's now my pleasure to introduce Harold Goodman and to present him with this commemorative bowl for giving this very distinguished lecture. Thank you.
I received a smaller bowl in 1969 when I had the good fortune to represent the law school in the National Moot Court competition, and was fortunate enough to defeat a school across the river, and then went on to defeat the BC Law School moot court team, which had been coached by Father Drinan, who was the dean of the law school then. And we moved on, Michael Fadden and Bill McCauley and I, to New York, where we made it to the national semifinals. So I was fortunate enough to get a bowl that is a highlight in my office, best oral advocate in the Northeast region. I'm not sure it was deserved, but it was a great experience and actually propelled me to be a lawyer, largely in public interest areas, representing poor people, particularly Black workers, women, disabled people, etc. So today's talk actually may be a bit ironic, if not sarcastic, maybe even oxymoronic, because I've talked about it as being the joy, the craft of being a lawyer, especially in the times we live in now, with issues nationally and internationally, with people suffering still from disease, and students with whom I'm glad to be a part today who have problems perhaps of student debt. What job am I going to have? Am I going to like it? Am I going to be able to succeed in it? So with that as kind of background, I want to talk about several of my cases and let you know why I feel the joy, despite the stress and frequently 7 days of hard work with lots of people, many of whom I was mentored by and many of whom I mentor, because it may make a difference to you at this point in your careers to say, can I get the joy out of practicing law despite all the stress? And for me, the answer has been yes, for 53 years now. I'm going to talk about several cases that have made a big difference. The first of which, by the coincidence of the calendar, was filed 51 years ago tomorrow by 12 black operating engineers, the people who operate cranes, bulldozers, forklift operators, etc., for themselves and a class of hundreds of others who happened to have one thing in common with each other. They were black, and they were the intentional victims of race discrimination. I'll tell you a little bit about the three phases of that lawsuit in a moment, but I do want to step back to tell you how judges are selected. Maybe you know this in federal court. It's random selection. There's literally a wheel, and depending on what moment of day that you file a complaint, you immediately get assigned to a judge who is with you from beginning to end, unless there is some event, a retirement, or a death that changes that. So on November 8th, 1973, we got assigned to A. Leon Higginbotham. How many people in this room even know the name or who he is? About half. Leon Higginbotham was a giant of a man. He was a fabulous, fabulous trial lawyer, having graduated from Yale Law School. He was a great scholar and a great historian. He was the first black judge appointed in federal court in Philadelphia. He stood 6'5", 6'6". I gave some comments last Friday at a big mural in his honor in West Philadelphia. And just to look at that mural and seeing his size recalled to me not just his stature, his grace, but he had the deepest baritone voice. And if your eyes were closed, you were listening to an opera singer, or imagine you were listening to an opera singer. So imagine I am now 26 years old, and I've been practicing law 3 years, and I'll touch on some of that later. I'm a graduate of this law school, and I ended up in Philadelphia by chance. I enlisted in the Domestic Peace Corps, then called VISTA, the Volunteers in Service to America. And they had a good rule. You couldn't practice law in the same area you came from or you went to law school. You wanted to be with strangers, people you were representing and you weren't distracted by friends and family. So after about a month of training in DC, how to live with, how to work with people who were poor, disfranchised, and needed lawyers that they weren't going to get anywhere else. I had three choices. Everybody had three choices of where they wanted to be in the Mid-Atlantic area. My first choice was DC. My second choice was Atlanta, Georgia. I got my third, Philadelphia. And I thought I'd be there a couple of years and return here. I was wrong. It's 53 years later. But it was in that setting that we filed this lawsuit and we get assigned to Judge Higginbotham. And there were three phases of that case that made me know that this is what I wanted to do. These are the type of clients I wanted to serve and get the empathy and ultimately the joy of the representation, even when the journey was hard and even when there were losses along the way. Stage one of that case occurred in June of 1972. My clients began being deposed, and they testified about just the color of their skin prevented them from getting jobs, because the only way you could get jobs was with a labor union that had an exclusive hiring hall with contractors. You couldn't go to the contractors to work. You had to get the jobs through the union. And the union, despite the fact that they were skilled, many of whom served in the Army during World War II, during the Korean War, they couldn't get jobs there. Others, sponsored by the federal government and went through training just to be able to enter the craft, get back to Philadelphia, stand outside looking for jobs through a union hall, and they were told, don't bother. you're the wrong color. That was not the phraseology that was conveyed to them. After the testimony of a number of these people, acts of violence occurred, acts which caused 3 people, Marion Eady, John Dent, and Cleveland Allen, on Vine Street in Philadelphia, to be attacked by groups of 50 white operating engineers, led by union officials with baseball bats and inside the union hall with chairs, and clubbed them all, not once, on 3 separate occasions. Philadelphia police were unable to do anything about it. So it seemed to me and the team we work with that we needed help. So we sought it from Leon. I call him Leon because I got to know him intimately over many, many years. Filed a motion for an injunction pendente lite. And the union appeared with their lawyers, and this was, I should pause to say, what's called a bilateral class action. So you had hundreds of blacks on the plaintiff class, a Rule 23b2 class action, and you had hundreds of contractors who had done business with the union on the other. And their position in court was, Judge Higginbotham, you and the federal courts have no jurisdiction over this. This is not a federal court matter. First of all, it's boys being boys. That was the argument. And beyond that, there's no jurisdiction here. If anything, it's with the Philadelphia police, which were unable to prevent this violence. Eady was a named plaintiff. He felt suicidal as about this. And I got a call one day, he was threatening to jump off the Walt Whitman Bridge. People with him had stopped that. John Dent, who became one of my closest friends, had come up from Atlanta. He was a heavy equipment operator who could operate the biggest cranes in the city. He was beaten up because he was there to support Eady. Cleveland Allen had operated bulldozers in Vietnam for 2 years. He was there to get a job, and he wasn't able to. He was beaten up. Case goes on for 3 or 4 days. We close. The union's lawyer makes the argument that I told you about. No jurisdiction. Boys will be boys. Judge Higginbotham announces at the close of the evidence, I'm going to issue an injunction, pendente lite, preventing any violence, any acts of intimidation against any member of the plaintiff class and against their lawyers, because we were threatened. But he said, I'm going to write an extensive opinion about it. So I'm going to issue the order now, and the opinion was delayed. Seth, could you hand me that file, please? 2 months later, in an opinion that spans 33 pages of federal supplement and contains 72 footnotes, Judge Higginbotham carefully disarms all of these arguments. He first concludes that a federal court has inherent power to enforce its own processes, and he had inherent power, therefore, to issue an injunction against violence and intimidation by defendants against the plaintiff class. But that wasn't enough. He traces the history, first, of the civil rights laws that were passed, principally in 1866 and 1870, better known as Section 1981 and the Conspiracy Copart 1985, 2, and 3. And he said that that's what the Congress then, most of you may know this, the radical Republican Congress, which passed the post-Civil War statutes, was done to enable blacks to utilize the federal courts. And so 1981 and 1983, 1985 sub 3, is the Conspiracy Copart to 1981. Authorized him to do it. But that wasn't enough because those statutes had to have a constitutional basis. So we trace the history of the 13th and 14th Amendments and how the Constitution was, of course, based initially, sanctioned in slavery, and then traced Dred Scott, Plessy, and Jim Crow. And then he said Congress in Section 5 of the 14th Amendment and Section 2 of the 13th Amendment had these powers to enable courts to issue protective injunctions in cases like this. And so in this very long opinion, where did I put it? it's worth quoting. Let me just take a look. Sometimes I have to be a magician in courtrooms. Here it is. It's worth reading. And so he's now responding to the argument that he's been making about the badges and incidents of slavery and how the violence perpetrated against plaintiffs in this class action was just a sequelae, an example of those badges and incidents of slavery. So it's worth quoting. Glad I found it. Those who are not students of American racial history might ask, what does the beating of black litigants in this case have to do with the badges and incidents of slavery? How can the attitudes of defendants be related to the institution of slavery, which was eradicated more than 100 years ago? The answer, he wrote, is that these racist acts are as related to the incidents of slavery as each roar of the ocean is related to each incoming wave. And he ends with this sentence: for slavery was an institution which was sanctioned, sustained, encouraged, and perpetuated by federal constitutional doctrine. Today's conditions on race relations are a sequelae and consequence of the pathology of centuries of that slavery. So that ended phase one of this case, which I will tell you went on for 26 years. Phase two was an attack on the judge. Case was supposed to try early in 1976 when I was still a young man. And earlier that year, 75, the judge had given a speech to the American Historical Society in which he spoke about the need for civil rights to not just be focused in courts, but as well on local, state legislatures, maybe with community activist groups, etc., and that these were vehicles perhaps just as viable, depending on your circumstance, to pursue if you've got a valid case. That was it. No mention of our lawsuit, no mention of anything about anything in federal court. The union and the contractors then moved to recuse him. That was delayed the trial for 4 months. He wrote another breathtaking opinion on how this never would have happened were he a white judge, and then used examples of many white judges making speeches on many causes, liberal and conservative, and yet not one was ever the subject of a recusal motion. Dissatisfied with the decision, the union and the contractors appealed to the Third Circuit, which affirmed, Supreme Court denied cert. So finally, in January of 1976, we began the class action merits trial, which lasted till June of 1977. Actually, that was not as stressful as it may sound. He gave us Fridays off. And he gave us 3 or 4 weeks off in the summer of 76. But with the exception of other cases that I had to work with that took a back seat, that was all the team and I focused upon. And at the end of this very, very long trial, he wrote about a 180-page opinion, finding class-wide racial discrimination intentional by the union, found vicarious liability in the contractors because their workforce was a product of what the union was providing to them, and then issued an injunction. Not long after that, President Carter appointed him to the Third Circuit, where eventually became the chief judge. The injunction part was referred to former U.S. Marshal, then a judge, Louis Bechtel. But it ultimately took till 1996 before that case ended with the payment of huge amounts of compensatory damages, reforms in the system, so that today there are really hundreds of Black and other minority operating engineers throughout Eastern Pennsylvania and Philadelphia. And one of the great pleasures I had one day is one of my clients took me up, shouldn't have done it, the top of what is the Comcast building in Philadelphia on the crane that he was operating. And I got a bird's eye view, 360-degree view of the rivers and the city itself. But the pleasure was not just in the view. It was just the feeling that I'd been a small part of changing people's lives. So that was the operating engineer's case in short rift. And now I want to turn to another case, which was called Bolden versus the Pennsylvania State Police, another race discrimination case. But I want to stop because there's a backstory here. Now I'm 25 years old, and just a year out of this law school, which had motivated me to do what I started to do. Some, by chance, but quite a motivation. And this backstory is I was asked to represent a man named Ozzie Hackett, who was the only black truck driver for a small laundry company in Philadelphia. And when there came time for layoffs, so he was the most senior, had a perfect record, everybody liked him, they laid him off and kept all the white drivers. That's because of customer preference for white drivers. So I'm appointed to represent him because he was eligible for community legal services, where I worked for 19 years, free representation. And there was a judge, Judge John Hannum, who threw the case out before we got involved. He did that because Mr. Hackett had applied for his union pension, which I think paid at that point like $30 a week. He needed that to take care of his family. Otherwise, he was destitute. That's why he was eligible for our services. But the judge says applying for the pension takes away your right to sue. You lack standing because you've retired, despite the fact the lawsuit claimed, I want reinstatement and damages. So the first thing we had to do before appealing that was to go to the judge to ask for IFP status. IFP stands for in forma pauperis. And we go to chambers. My opponent was there, not opposing the motion. And Judge Hannum said to me, I'm going to deny your motion. I said, but Your Honor, he's eligible for free legal services. It's the only way he can pursue the appeal. Well, that's not why I'm denying it. He pointed to an oil painting. It was of Ulysses S. Grant. And he said, Mr. Goodman, that man changed everything. Civil War. I said, Judge, Congress passed, President Johnson signed into law Title VII of the 1964 Civil Rights Act. No matter, petition denied. Go up to the Court of Appeals, reverse him on that, reverse him on the merits, go to trial. Mr. Hackett gets his job back and back wages. Why am I telling you that backstory? It's not a high-profile case, but it takes me to the state police case. Judge Hannum, not long after that, retired to a horse farm that he had in Chester County. And yes, there's an implication in what I've just said. And we got now another wheel, because this case I've just begun to describe against the state police is filed. And who gets assigned the case? Clifford Scott Green, who had been a partner with Judge Higginbotham, Austin Norris, Bill Brown, as the first black law firm in Philadelphia. Not because they wanted to form a black law firm per se. None of them, despite their credentials, could get jobs with white shoes law firms in Philadelphia. And that's how they became fabulous lawyers, and many became judges. So now I've got Clifford Scott Green. And we tried the case. At that point, the state police had been in existence since 1905. 1905. And they had a policy and practice. No blacks need apply. You will never have a job, ever. It is only in the 60s that 5 or 6 who had served in all sorts of police assignments with the Army in Vietnam got admitted. But at the time we filed the lawsuit with a number of individual plaintiffs, there were 42 black officers, all at the lowest rank of trooper, out of a force of 4,100 and change. And so at the trial, there's a great deal of testimony about the nature of the discrimination. black police officer who wanted to be with the state police said, I went to the Belmont Barracks near Philadelphia, and I was told if I want to apply to go to the back door, which was locked. Went back another time, said, look, you got a job with the Philadelphia police. Don't bother here. He didn't care. I want to apply. You're black. Forget it. His name was Bill Bolden. So he testified, and many others. I have never seen more credible people in my life. This were first generation Jackie Robinsons, all of them. They stood tall. They were not angry. They just laid out their stories of denial. And then I called one other witness, a statistician, Dr. Bernard Siskin. He was chairman of the Temple University Statistics Department. And I called him as my last witness intentionally. After being credentialed and allowed to testify as an expert, I asked him what he had done. He said, well, I studied the labor force of what would be officers in Pennsylvania based on the qualifications set by the state police. High school, GE degree, taking an exam, an oral interview, etc. What did you find, I asked. I find that 10% of the labor force in Pennsylvania is black and qualifies to be state police officers based on their published criteria. At the same time, I said, you've only got 42 black people as officers in the lowest rank, which roughly, I think, came to about 1.4%. Now understand, even young lawyers like me have to prep your witnesses. So I'm about to tell you it didn't come out of the blue, but I think it sealed the deal. So I said, Dr. Siskin, can you tell me as a statistician, what is the statistical likelihood that there could only be 42 black officers in the state police out of more than 4,100, given the fact that blacks comprise 10% of the labor force in Philadelphia for that job? And he said to me, Mr. Goodman, understand, he's at the witness stand. Do you have a coin? Yeah. Heads on one side, tails on the other? Could you flip it? He asked me, what is it? Tails. Well, the chances that there could be so few black officers in the state police under those circumstances would be the same with that same fair coin if you flipped it 100 times. And each time it came up tails, or each time it came up heads. Oh, I like this. Can you give me another example? Of course, this had been prepped. He said, sure. Imagine that you are at a casino playing poker. And with a fair dealer, a fair deck of cards, and you were sitting in the middle on 10 consecutive occasions, it came up royal straight flush. I have no further questions. My opponent, who was from the Attorney General's office, who had a good heart and didn't want to be there, was asked by the judge, any questions, Mr. Lerner? No, Your Honor. Milton Schaap was the governor at the time, and at the end of the trial, before the judge ruled, and it was clear he was going to rule in our favor, he agreed to enter into a consent decree which would cause both the integration of blacks and other minorities to the state police and promotions. And that was entered as a decree of the court because it was a class action. Unfortunately, for 3 years, the state police refused to promote or hire anyone, even though they've been authorized to do so by the state legislature, which, dominated by the wrong party, refused to intervene. So we had to file a motion for contempt of court. Judge Green then issued an order increasing the affirmative action, do I dare say that phrase? I do, requirements for the state police, held them in contempt of court, and then there began to be a flood of qualified black applicants and people who were promoted. But that wasn't the end of it. Individual black police officers were the victims of retaliation not once, but 9 times. Each time Judge Green held hearings, found in our favor. Each went up to the Third Circuit. I don't think it was anything I could take a lot of credit for. Each time Judge Green was affirmed. And it was in 1989, when then Governor Casey was the governor, that he appointed Ronald Sharp, one of my clients and someone who became a close friend, as the first black state police commissioner in Pennsylvania, and we think maybe, in the country. And I have a wonderful picture, along with my Paul Revere Bowl, in which I'm cradling my daughter in one hand, my wife by my side, and the governor and his wife presenting the honors to Ronald Sharp as the first black state police commissioner. So cases like that have given me not just the pleasure, although there's been a lot of stress and setbacks along the way, but I think the empathy and the opportunities that I was looking for. I just want to touch on a few others before I open it up for any questions or comments that you might have. Lily Bell Allen, otherwise unknown to the world, but what I'm about to tell you has made her prominent. Lily Bell Allen grew up and lived in Aiken, South Carolina. Her father was a pastor, mother worked as a domestic and worked in the church. They had another daughter named Hattie. Hattie moved to York, Pennsylvania, and married, and went then by the name of Hattie Dixon. So Lily Bell Allen, then with two children, Deborah, 12, Michael, 10, drove in their car from Aiken, Georgia, with her parents to see Hattie, her husband, and spend some time there. Everything was fine the first night. They were staying at Hattie's house. The next day, family decided to go to the grocery store to get enough food for the week stay that they intended to be there. So they left Deborah and Michael with two aunts and uncles, Hattie, her husband, in the front seat, Lily Bell, her parents, in the back seat. They were driving an old Cadillac, which will become important to you in a minute. Before they got to the grocery store, they had to pass by Newbury Street, not this Newbury Street where I got reacquainted yesterday on a beautiful day. They got to Newbury Street, and before they knew it, hundreds of gunshots rang out at the car. Hattie stalled the car, panicked, lay down on her husband's lap, who crouched over her. The gunshots continued. Lily Bell, thinking that she could do something, got out of the car to get to the driver's seat to try to drive away. She was killed on the spot. No one was ever arrested or convicted on it for 20 years. And then a suicide note was found. The suicide note was from one of what were called the Newbury Street Boys, who lived in this white neighborhood, heavily involved with the Ku Klux Klan, which was acted in and around the Mason-Dixon line. And in his confession for the guilt that he had carried, he had said the police and the police chief had armed the neighbors. Any black people who come through this neighborhood in a Cadillac, you shoot. Why? Because about a month before, another black man driving a Cadillac engaged in some verbal altercation with a police officer. This was payback. They thought it was that person, but just ended up killing Lily Bell Allen. That got the feds involved, the state government, and there was a trial of the then mayor of York, Charlie Robinson, on second-degree murder charges, and a number of the Newbury Street Boys. By that point, I'd been retained to represent Deborah and Michael, who were adults, for the estates that were opened for their mother. And finally, we filed a lawsuit in federal court over that. And the defendants, in a civil case, moved to dismiss. You can probably guess what reason. Statute of limitations, and yes, that phrase, qualified immunity. Well, the federal judge denied the motions. As far as statute of limitations, the events that I've just described and learned about were knowingly concealed from the plaintiffs, and therefore collateral equitable principles applied, and they acted promptly once the truth came out. And as far as qualified immunity is concerned, no matter how you define the term, It clearly was known to even a rookie cop that killing people because they're black doesn't shroud you in immunity, but rather guilt. Denied. Case goes to the Third Circuit because you can appeal qualified immunity decisions immediately. And the court was composed of Judge Samuel Alito, Edward Becker, and Judge Diamond, who was a district court judge sitting by designation. By that point, I'd argued more than 30 cases in the Court of Appeals. Actually, now it's a few more than that. And I've never in my life had a case where a federal court of appeals issues a decision that very day. The only one who gave me trouble is Alito. And he just questioned the qualified immunity issue on the question of race. But I think my answer satisfied him. Becker was the chief judge sitting in the middle. And normally when it's done, they say, thank you, counsel. Take the case under advisement. You wait a decision. And I think as we were leaving a pretty filled courtroom, Judge Becker says, everybody wait, please. We have an opinion. And he had the opinion all written out on a yellow pad, unanimously saying, A, the discovery rule applies, statute of limitations can't be used as a defense, and then looking at the lawyers for the police, said it is offensive to this court that anybody would suggest that there's qualified immunity for killing someone under these circumstances because they are black. And courtroom erupted. And my father, who's passed away, and my mother were there. My father was deaf at the time. And he said, why are they clapping? So that was a joy. I am able to continue to talk about my cases, but that wasn't really the point. It was, as I said, the joy of being a lawyer, given the opportunity to do civil rights work. And I think there are more opportunities today than we know. And I hope some of you, the students, will take that opportunity to maybe consider a career in public service, working for many of the nonprofits that represent disabled people, elderly people, public interest law centers, and have the opportunity that I do. So that's why I call it the joy. But I was thinking, how can I end this? And so, I'm thinking of Frost stopping by woods in a snowy night. You may remember the last stanza is ending with the phrase, I have miles to go before I sleep, miles to go before I sleep. I don't have too many, but I think you do. So thank you for listening. So does anybody have a joke, a comment, a poem, preferably a haiku?
Not poem, but I don't know if it's a joke. In more than half a century, in addition to the cases you've talked about, surely there must have been more than your share of stinkers as well. Things that would be about as much fun as law professors grading exams and serving on committees. And I'm wondering what you would tell students about how to manage their mindsets when they get the crappers, or like I suspect your opponent in the police case, they actually may wish they were on the other side. How do you navigate that?
First of all, I'm not sure that's a perfect metaphor. But I think the honest answer, you've got to be straight. No matter how empathetic you may be, if you think it's a crapper, I think you have a duty to that client or potential client to say so. That was a lesson that took a while, for me to learn. But if you are not honest that way and lead people on, I think you create an expectation which you, no matter how skillful you may be, you'll never be able to satisfy. Now, there are times when you get appointed by a court, and it's really difficult to get out of that, but that also suggests to me the same answer. You have to be honest. You know, and I've had setbacks, including some of the cases, you know, that I've talked about. And one of which was the end result in 1983 of this operating engineer's case, although it really didn't do any damage. Remember I mentioned that the employers were found liable by Judge Higginbotham simply because they relied upon a union that practiced intentional discrimination, and thus the injunction applied to all of them. Cert was taken on that case, and we lost 6-3 on that singular issue, not the relief, but we couldn't get it against the employers. And I thought the argument went well. There were a lot of interveners. And I remember going on a run and just stopping in the middle after the decision came out, you know, feeling dispirited. But I was cheered on by my wife and clients who said, look, the same relief is going to happen, hopefully, with the union. And we've already got millions of dollars of damages. So that was a setback on a good case. I can remember one where I represented a whistleblower and had a 2-1 victory in the Court of Appeals. And then on remand from a motion to dismiss that we had got reversed, I learned some pretty bad things about the case. I thought we should resolve it on modest terms. And this client said to me, no, I want to go forward and it's worth X millions. It absolutely wasn't. And it was one of the hardest things I did because I put a lot of time into it. We won at the Court of Appeals on a motion to dismiss, and we had to move to withdraw. And we did. Another lawyer got involved with the case, then it was thrown out on summary judgment. So I think there are stresses along the way, there are losses along the way, but like the Red Sox occasionally, you know, it's a journey, and you got to take it with you and realize that there'll be another day. At least that's the way I look at it. Yes?
So I imagine that your clients in the machinery case weren't surprised by the reaction of the people in the union. I wonder if you were, and I wonder if in other cases that you've had, your clients sort of educated you about the way their part of the world worked that you didn't have experience in.
Yeah, I'm this guy from Boston who still, you know, says I parked my car in, you know, whose yard, and, you know, did a lot of growing up as a human being and as an adult in Philadelphia. But I think your question is terrific because it touches on, you are not just the hired gun, you're not the warrior. You got to be a good listener and know what your clients are going through and experience that. And the truth is, I was told, particularly in that operating engineer's case, you got to be careful. Get an unlisted number. And I was threatened. I was threatened that someone was going to come to my house and shoot me. Briefly, there was an FBI agent assigned to me back and forth to court, because I think I told you the trial went on, you know, forever. Yeah, it's a learning experience for the lawyer as much as it is in reverse. Sometimes you don't want to believe it because you think maybe you're invincible, but I've been educated as much by clients as I hopefully have served them. Yes.
So I thought I heard in your talk, I'm not sure I did, another answer to Gary Lawson's question, the first question, which is, you know, you had a career that did have a lot of joy in it, partly because it had great successes, and they were great successes that made differences in people's lives. But you must have had clients, or at least most of my students are going to have clients who, when they want to do the kind of work you do, they're going to have clients who are in the right in their eye, the lawyer's eyes, and they're just gonna lose, and bad things are going to happen to them. And I always tell my students, and this is what I think I heard at points in your talk, I always tell my students, you know, to survive a world where you're going to lose on a regular basis, say you're doing criminal defense, you're going to do a lot of losing. You have to think about your career as, the satisfactions have to be that you are doing what you can for that human being and you're connecting to that human being and you have that connection with them. And if they get nothing else out of whatever horrible thing is happening to them, they get this feeling that they've been understood by one person in the system who is there for them. And then you as the lawyer, you're not in their position, but you go home at night and however much you've lost, you have, I'm hoping, some deep feeling of satisfaction that you were able to do something.
I couldn't agree more. I think that's the part that empathy plays in the process. I've been fortunate because of case selection. And case selection means even when you have a good case, if you're so involved in others, because our work has never been volume, it's always been, I'd like to say quality. I will turn down a case if I can't immediately or over time give it my all. So I think you make a pact with clients and say, we're in this together. I have to know everything, and I'll tell you everything, and I'll do all I can for you. And if we lost, we'll lose together, but we'll go down vigorously. Or on occasion, I cannot represent you because I can't possibly achieve your goals. And I think it happened just once in my career. It moved, to a draw. So I mean, let me just carry that over to an existing case. How many of you have heard about a doctrine which is referred to as the state-created danger theory? Boy, no hands. So government, says the United States Supreme Court, has no affirmative duty under the Due Process Clause, speaking about substantive due process, to affirmatively help people in danger, except in those limited situations when they may be incarcerated or have a special relationship with them in some sense, a ward at a mental hospital, for example. But they created this sort of exception that if the government affirmatively does something that causes harm to an individual, as distinct from failure to act, then that can be actionable. Why do I mention that? Because presently, back in York, Pennsylvania, where I am persona non grata, I represent a woman, I'll just call her Marissa. Marissa was married to a Baltimore cop for 14 years. In August of last year, 2021, he was fired, sexual harassment, abuse, and other misconduct. He and his wife had a marital home in York. They were going through a brutal custody battle under which he had them, the children, over the weekend. She had them during the week. He was in Baltimore. She was seeking more custody. So one weekend, 1 year ago virtually today, he comes up having just been fired by Baltimore with an accomplice, a woman who worked as a cop in the Special Crimes Unit. And they had the two children at this marital home. And they invited Marissa over because it was her birthday. Let the children see you, we'll have a cake. Seemed harmless enough. And she did. Just as she was leaving, as the kids were going to bed, children, Gianna and Amina, 7 and 6 years old, went to sleep. And just as Marissa was leaving the house, her husband, her ex-husband, said, "Wait, we have something for you." They dragged her downstairs, tied her arms and legs to a table. He drugged her, raped her, repeatedly over 2 days. Sunday, this happened on a Friday night. She had a job. So I'm going to let you go home. You get your clothes, bring your computer back here, and you say nothing to anybody. And if you say anything to anybody, I'm going to kill the kids and kill your family. As she recounted it to me, Marissa said, when I left, I had one thought. I'm going to get my brothers. I'm going to go back. I'm going to get the kids. If I have to, I'm going to kill them. If I have to go to jail because I killed him to save my children, I'm going to do it. Took a deep breath. I said, I'm going to the police. I'm not going to go through the long travail, and she does. And the police find the whole story credible, put her through what's called a rape kit to see that she was raped, find out about the kids, and detectives want to conduct surveillance, get a squad there immediately to get the kids out. They also get 2 court orders, an emergency protection from abuse, and a search warrant. The chief of police was busy that day watching an NFL football game. Didn't want to deal with the detectives on the scene. And he told the cops through his lieutenant, who was not at the scene, because this evidence is now uncovered, the lieutenant was drinking and didn't feel that he could make it in. So the order went to the cops ready to serve the warrant, 9 o'clock that Sunday evening, and to get the kids, or at least put them under surveillance. And they were told, if you do that, you're going to be fired. So they didn't serve it. Why did the chief want to do it? 2 reasons. He and other cops lived in that neighborhood. And he was fearful that if there were shots that rang out, he, his family, others might get shot. And the other, he acted on a misassumption that the children were going to school. And at 8 o'clock, there would be a bus to take them. And then they could be saved. Of course, he never asked. They weren't. They were homeschooled. That's the basis of our lawsuit, the affirmative act by the police. And we're about to file that lawsuit later this week. But it is to just get to the question about those cases that might not lose, not because they're bad plaintiffs or the stories don't. This is a case where the law is going to be really pushed, because I think the Supreme Court could completely do away even with this limitation. Our theory is, had the police acted on time, what happened wouldn't have happened. Because what happened is her husband, with her as accomplice, when he realized she didn't come back, fled the neighborhood, pistol whipped one person to get another car, pistol whipped another woman to get another car. By now, you've got Amber Alerts out. Cops are following them. He drives into a small creek. I'm sorry, his accomplice driving the car drives into a small creek. He then shoots her and kills her. Shoots the 2 children, his daughters, kills them, and turns the gun on himself. The theory of the case is this couldn't or wouldn't have happened, but for the police affirmatively saying, don't conduct surveillance, don't serve these warrants. And as good, and the facts are this way, because this Attorney General's office has done a factual investigation. That's how we know about it. But a lot of people think it's going to be very hard to hold the police accountable because this guy's a bad guy who would have done it anyways. Can we lose that case? Not without a fight. So it's a longer answer to your question. It's not a clinker, but it's one which will test, I think, the law's limits. I think we'll survive a motion to dismiss. We'll see what happens. But that gives me motivation to catch the plane so I can get back to Philadelphia to work on the complaint. I'm not trying to end this too quickly. So sorry for the long answer to your question, but there are clunkers and there are good cases, but even the good cases have kinks in them that might result in defeats. Yes.
Hi, thanks for your remarks. It was really interesting presentation. I stopped being a trial lawyer because I liked peace and I don't like fighting for a living. And I wondered if you could speak on kind of the civility of the profession and how you found your interactions with opposing counsel from the beginning of your career till now. We've certainly seen a decline in our civil discourse in politics. Are you seeing that in court, and how have you handled that?
That's a good question. I think as a younger lawyer, a bit naive but highly motivated, I got to see a lot of the worst in opposing lawyers who thought they could take advantage of someone who still spoke with ahs in his voice and wasn't long out of law school, and there was a sense of taking advantage. And I don't know if it's something in my makeup or my own parents, or played a lot of sports, but I began to overcome that. I think, as you get a reputation It a lot depends upon who your opponents are and then who the judges are too. Like right now, for obvious reasons, for the type of practice I and my staff has, it's much more difficult to get judges to even understand the basic legal theories. More recently, opponents have been far more difficult. I don't know if it's the pandemic, which has largely shut down courts, which are beginning, to reopen. People are contemptuous towards my clients, being very, very difficult. To give you an example, a major law firm's lawyer in a disability discrimination case in which I'm representing a victim of cancer wanted to go back to work, and they didn't want her because they thought she's going to need more reasonable accommodations, so we don't want her. My opponent's saying, I refuse to allow you to take any depositions until I take the depositions of your client first, even though I had noticed them first. And he refused. And I just got news earlier this morning that our motion to let us take deposition whenever we want them was granted, and my opponent is supposed to pay our attorney's fees, which wasn't much on this. So I think the answer is, generally the bigger the law firm, the more civil they've become, because that's the way they've been taught, with exceptions. The more you get into the pits with sole practitioners, et cetera, more uncivil. But I get motivated some point by that, I get annoyed. I won't, deny that, but all right, you want to play it that way? We'll act in kind. So it's been an uneven playing field, but not enough to disarm me. Yes.
Hi, thank you very much for that. Really interesting. And I had a couple of questions. One is a sort of specific. I teach a civil rights litigation course, and we always talk about Rizzo versus Good. And I'm wondering, you were in Philadelphia, I gather, at the time when that litigation was going on, and I wonder if you had any acquaintance with what was going on or involvement or whatever. And then the other question, which is sort of how are things different today, not in terms of lawyer civility, but just in terms of the kinds of things that you have to deal with in Philadelphia now? I mean, I'm guessing there's no more state agencies that have an actual policy of not hiring black people, but I'm not sure that the climate in Philadelphia is all that more welcoming for people, and that's what I'm sort of interested in.
Thank you for the question. The answer to the first is my office, Community Legal Services, represented the plaintiffs in the Rizzo case. In fact, we had many cases against former Mayor Frank Rizzo, including one on Whitman Homes, which is in South Philadelphia, which has always been a bastion of Frank Rizzo, to open up public housing to black people there. So we were involved in that. My role in it was limited to arguing it in the Third Circuit. That was part of the work the Community Legal Services did. We represented an awful lot of community organizations. The dean mentioned fresh out of law school, I think it was 7 months, I got to represent a sort of Ralph Nader consumer education group that, prior restraint against peaceful picketing outside, the sidewalk got me to the Supreme Court to argue a pretty easy prior restraint case. So it was the sort of work that we did representing what was called the Resident Advisory Board. So we were very much involved with that. Yeah, things have changed a lot for the worse. In the almost 20 years since the state police case ended, which I told you we reached a plateau of 600 officers, it's now down to about 300, because many who came on during the course of our career retired. You can retire as a state police officer at 20 years and get 50% of your highest salary. If you do it 25 years, you get 75%. So a lot were leaving, and very few were coming on. So we've been asked to get back involved with that. Philadelphia is a crime-ridden city, not perhaps different than Boston. And there is a lot going on in which people say the right things, as you alluded to. We will not discriminate against anybody for this reason or that, but frequently on it more in the lurch than in the substance. So that's why I say I've got miles to go yet. Well, thank you for having me. I appreciate it.